Business agreements are often summed up in a contract. The idea being that if the parties have a problem, they know how they're going to handle it based on what the contract says. Well, in theory, that seems to work. In practice, things tend to be different. The reality is you need to understand how to solve problems when they arise in a contract. And the solution should be bigger than just litigation. I mean, the idea of suing somebody might seem like a good idea, but the problem is that such is so adversarial. I mean, it's you versus them. And the problem with that is not only do you destroy the relationship you had with that party, there is also no guarantee that you're likely to win. So, what you're left with are understanding other alternatives to dispute resolutions. Okay, so let's talk about dispute resolution mechanisms. According to the 2001 UK Office of Governance Commerce Guidance on Dispute Resolution techniques can be viewed as a continuum that ranges from the most informal negotiations between the parties themselves through increasing formalities and more direct intervention from external sources to full court hearing with strict rules of procedure. What you need to understand is that if you don't solve a conflict in a contract, in fact, if you don't solve a conflict in whatever it is that you're dealing with, the conflict is just going to escalate. I mean, if suppliers fail to deliver goods in time, and then you're okay with that, what is going to happen is that they're going to get used to that, and then things are just going to get worse. The question is, why do contractual disagreements arise? The first thing you have to understand is that disagreements are not necessarily as a result of negative things. I mean, disagreements in a contract. So they could be as a result of things such as the desire for one party to alternate the contractual terms due to arising circumstances such as changes in the business environment. I mean, think about it. If there is a new law, for instance, whatever is happening around the Brexit and all that, see, those are some of the things that will mean the sort of contracts that people got into between, say, the UK and the rest of the European Union, assuming the thing goes through, they'll have to change those contracts. I mean, at some point, okay? So that could be a reason why the parties are disagreeing in a contract. The second reason could be delivery, payment, or quality problems. Number 3, interpretation of the terms in the contract. Well, first of all, if you don't understand how contracts work, I did a course, okay, on contract law, which you can just check out. The link is in the video description. So terms of a contract are the duties and obligations of the parties in that contract. So understanding the term of a contract is the first thing to understanding how the contract works, because the whole idea of getting into a contract anyway is just putting terms there, okay? Putting their duties and the other party's duties. And these duties and obligations are actually what you're calling the agreement, okay? A legally binding agreement. So the other reason could be failure to understand certain requirements in the contract. Now the question then becomes, how do we handle disputes if they occur or if they arise in a contract? So there are a number of ways in which you can handle disputes, and the first one is negotiation. From a purchasing point of view, negotiation is a process of planning, reviewing, and analyzing used by a seller and a buyer to reach acceptable agreement or compromise, which include all aspects of business transactions and not just price. You see, negotiation will actually work at any given level of the contract, but the trick is realizing how to be a principled negotiator. So how do you become a principled negotiator? Well, it's easy. Not necessarily as easy as I'm saying it, but it's easy if you practice. So these are some of the things you have to pay attention to if you are going to be a principled negotiator. Number 1, separate the person from the problem. That way you deal with the problem without creating negative relation. Remember, there is the thing that you are not agreeing on in the contract. It could be the quality. So talk about the quality. Don't worry about who the person is. Don't start attacking the person, because then now you just create another. In fact, you create 2 problems. There is a contractual problem and then there is a relationship problem. Number 2, focus on bringing your interests together and not your positions. So the thing is, the parties who are negotiating in a contract may not be of a similar position. You could be the procurement officer negotiating with, I don't know, some sales guy or sales director, whatever it is, in another company. These are 2 different positions. So don't focus on your positions, focus on the interest. What exactly is it that you want in that contract and what do they want? And that's what you focus on. So the third one is come up with various options and ideas instead of just pushing for a predetermined answer. And last one, try to ensure that the agreement reflects some objectively fair standard. Assuming you don't want to negotiate, or assuming the negotiation thing just isn't working for you. Another way that you can handle disputes in a contract is through mediation. What is mediation? Mediation involves the appointment of an independent person whose job is to hear arguments from both sides and make formal proposals or recommendations that is not binding to either party as a basis for settling the dispute. With mediation, this is what you're talking about. There are the two of you, you and the other person, you can't seem to agree, so you go to a mediator, a third party. So the third party is just going to be, it's just the third party is helping you to come to an agreement. You're still going to solve the problem on your own. The third party is only there to make sure that you do it. So the process will go something like this. Number one, opening joint meetings in which the parties briefly state their positions. Number two, a series of private and confidential follow-up meetings between the mediator and each of the teams present at the negotiations. The third thing, where applicable, joint meetings between some or all members of each team. And finally, signing of written settlement terms, assuming an agreement has been reached, because sometimes you don't end up reaching an agreement. So mediation sort of works that way. The key thing to understand with mediation is that you are still solving your own problem. The mediator is only there to see that you remain objective during the problem solution process. It is important to distinguish between facilitative mediation, where the mediator assists the parties on effort to formulate a settlement, and evaluative mediation, where the mediator additionally helps the parties by introducing a third-party view over the merits of the case or the particular issues between the parties. If things don't go according to plan, you couldn't negotiate a settlement, the mediator couldn't help you, then it means the two of you can't seem to solve the problem. You can't seem to arrive at a settlement. So what choice do you have? Arbitration, that's another choice. So with arbitration, you're talking about still there is a third party. The only difference is that in this case, the two of you are agreeing to do whatever it is that the third party has said. So the third party will hear the issues from side A and issues from side B, and then make a decision, and the decision is going to be legally binding. Now, this is not the same as a court, okay? You see, with a court, it's called litigation. We will look at that. This is just a situation where you're saying, look, we can't fix this problem, so you listen to our problems and then tell us what to do. What is the court's position during arbitration? Generally, courts don't interfere with the arbitral process unless it becomes clearly necessary that there is some sort of injustice going on, or there is a need for the court to step in. And the way the court can step in is usually going to be along the following lines. Number one, compelling appearance of a witness. Number two could be give a ruling on preliminary point of law if it concerns a matter substantially affecting the rights of one or more parties. Number three, enforcing the award made by arbitrator. Arbitration has a number of advantages attached to it, and such advantages will include there is a degree of confidentiality since the proceedings are held behind closed doors. Number two, compared to litigation, that is the lawsuits, the process is less confrontational. Number three, there are no appeals since it is intended as a single process. And number four, the process is faster and less expensive compared to litigation. Also, the parties gain advantage of accessing expert knowledge from the arbitrator. Of course, the process is not without its own fault. So there are a number of disadvantages that could be attached to arbitration, and such will include cost of arbitration may be high. The process is not suitable where coercive action such as an injunction is needed. Remember, an injunction is just a court order, or a court order that could command something to be done or could prevent something from happening, or it could be a temporary injunction, which is just this won't happen until something else happens. So, that's what an injunction is. The point is, if you don't understand, again, if you're having a problem with the contract law, as I mentioned earlier, there is a course I did, a summarized course. The link is in the video description. You can go check it out, study more about contract laws. Also, let me know if you have any issues regarding whichever part of the law. Now, moving on. Number next, the opponent may fail to cooperate. Number four, there is little or no right of appeal in case the decision isn't satisfying. So if all those techniques that you've talked about fail and you still haven't handled your problem, you still haven't arrived at a settlement, then you can go to the court, which means litigation. The problem with litigation is that it is adversarial and should, again, as you pointed out, be the last resort. So with litigation, we're talking about you suing the other party. It's where the dispute is handled in the court. Of course, it has a number of advantages attached to it, such as courts have more power, it is efficient, one doesn't have to pay for the judge's time, one can sue more than one party, and the verdict can be appealed. Of course, the question of appealing a verdict will depend on the court structure in your country. Remember, the rule is only superior courts can overrule the decisions made by subordinate courts. So you always have to understand the court structure in your country before you decide to appeal, before you decide to file for an appeal. Of course, the process also has disadvantages. So let's talk about those ones. And such include the process may be costly. The matter may continue in court for a long time. There isn't much of privacy in courts. Litigation can be complex when the contract is of an international nature, and the process is adversarial, which means it may damage the relationship and the good nature of the parties involved. Remember, when it comes to dispute resolution, you have a choice, okay? You always have to ask yourself, do you want to win, or do you want the relationship to continue, or in fact, do you want both? So depending on whatever it is that you want, you'll make a decision, okay? Do I negotiate? Do I use mediation? Do I use arbitration? Do I use litigation? The choice is up to you. If you have any question up to that point, let me know. I'm Moses from Zerite Network, and I'll see you in the next lesson.